the aspect of this particular issue has been dealt thoroughly. Paragraph 34. It is submitted that in a subsequent judgment of the Sovereign Court at Kiltai, Shirur was sought to be explained as stating that there are religious practices which are essential and which are not, and that only the former would be entitled to the protection under 26b and not the latter. The court in Kiltai to determine whether a particular religious practice is essential or not. This approach adopted by the Sovereign Court in the committee of Kiltai is completed by the learned orders by fourth edition body. According to the learned order, this deviation from Shirur Mutt and Durga Committee of Kiltai is omitted and only provides to substitute the court's opinion for that of the religious denomination as to what are the essential and non-essential parts of religion. Similarly, Lordship's issue number 5 is open excommunication review with regard to religious practice as referred to in Article 25 of the Constitution. In Shirur Mutt, the Sovereign Court had not essentially uphold the autonomy of the religious denomination to determine what would be considered as essential religious practice. The relevant paragraph contains under Article 26b. Therefore, a religious denomination or organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the religious belief, and no outside authority also has any jurisdiction to interfere in the decision of such matters. It is submitted that the aforementioned extract would suggest a complete autonomy for the religious denomination to determine whether any practice is religious or otherwise, religious or secular. The Sovereign Court did not deal with the distinction between essential religious practice or otherwise. The distinction dealt with or referred to was between a religious practice and a secular one. The Sovereign Court in Durga Committee emphasized the need for the judicial statement dealing with matters concerning religious practices. However, this court cautioned that the judicial interference must remain circumscribed and exercised directly, ensuring that only those persons which are clearly exchanged as non-essential fall outside the protective ambit of 2615. This is what we mentioned in Durga Committee, which is not by submission. While the core religious practices of the denomination continue to remain insulated from unnecessary judicial. The Sovereign Court in Kiltai did not rule there are religious practices which are essential, which are not, and the former would be entitled to protection under 26b and not the latter. The court in Kiltai thus took a different from Shirur Mutt by introducing the concept of the court exercising jurisdiction to determine whether a particular religious practice is essential or not. This approach adopted in Kiltai gave the order, except survive. I just read the extract. In Kiltai Sri Govindalal, this Gajendra again adverted to the rights of the 25 and stated that if a matter was obviously secular and not religious, who could be justified in rejecting its claim to be a religious practice as based on rational reason. It is submitted that the real question is whether the religious denomination looks upon it as an essential part of its religion. And however, irrational it may appear to persons who do not share the religious belief, the view of the denomination must be vague, for it is not open to a court to describe as irrational that which is part of the denomination is religion. The actual decision indicates that the right to manage the property of a secular matter is correct, but that is because as pointed out by this Article 26b, when contrasted with Articles 26c and d, shows that matters of religious belief and practices are distinct and separate from the management of property of a religious denomination. The distinction between religious belief and practices which cannot be controlled and the management of the property of a religious denomination which can be controlled will be managed. That is also controlled to a limited extent is recognized by the article itself and must be enforced. But this distinction is not relevant to the question whether a religious practice is irrational or not. If Shirur Mutt has been diluted to some extent or not, Durga Committee have taken the same path. Not the Shirur Committee, which is by That would also be an answer as to whether the two is the third. If at all there is a difference for distinguishing a religious practice and a secular practice, and not determine whether the religious practice is not the way of the book, not right. Therefore, my Lord, I say so in paragraph. Submitted that the court could be an arbiter of what is a religious practice. But I should have said what is a religious practice and what is a secular practice. But then I make it clear. It is submitted that the court cannot embark upon an inquiry as to whether what is distinctively a religious practice is essential. It's not a problem. Whether you do it generally in a constitutional jurisdiction or it comes about not in any other school itself, that is not an area or a domain where the court might. It is submitted that the individual's right to freely practice equity under 25(1) cannot run counter to the right to the same religious denomination of religion under 26(3), where therefore religious only exception thereto could be where a religious practice could be questioned on public order, health or morality. It is submitted that the right under 26(b) is not subsumed by the right under Article 25(1). In fact, the right of every individual belonging to a religious denomination under 25(1) will have to be in sync with the right claimed by the religious denomination under Article 26(b). It is submitted that the Honorable Court in Venkatramana Devaru, while upholding the right of the religious denomination under 26(b) in matters of religion, had observed that the law under 25(2)b would prevail over a right under 26(b). It is submitted that this principle is also made subject to a caveat, that this could only be in cases where the right under 26(b) would substantially reduce the right conferred under Article 25(2)b. It is submitted that Venkatramana Devaru did not consider, and this, my Lord, your Lordships may kindly note, Venkatramana Devaru did not consider a face-off between a right claimed under 25(1) by a member of a religious denomination and the right of the denomination itself under 26(b). Then, my Lord, 42, I just referred to two judgments, my Lord. It is submitted that the concept of an essential religious practice would have different connotations. Yes, my Lord, that is, I just referred to two judgments, my Lord. In 43, I say, my Lord, that I referred to.
You have summed up in 44.
Yes, I have summed up within 44. Thus, a religious practice which is integrally related to the characteristics of the deity would be completely captured by the right claimed by the religious denomination under Article 26(b). As a sequitur, no member of the Hindu religion could assert any right in antagonism to the said religious practice of the religious denomination. It is submitted that the principle that an individual's right under 25(1) to practice a religion cannot be in antagonism to the right of the religious denomination to manage the affairs of its religion, including an affirmation of the integral religious practice, would be applicable to all religions, though the facets of the right relatable to the characteristics of a deity may be applicable only to the Hindu religion. It is submitted to the Honorable Court in Shirur held that a question as to whether a practice is a religious practice or not will have to be determined with respect to the tenets of the religion itself. This facet of the dicta in Shirur was thought to be reiterated in Shishamad and Commissioner of Police, that is the Anandabharti's case as such. My Lord, issue number 4 is regarding morality, my Lord. I will not trouble your Lordship. So much has been argued, my Lord, on that. It has been argued in detail, my Lord. Therefore, I don't want to trouble your Lordships on that also. My Lord, so also regarding section of
Issue number 6.
That's also regarding section of Hindus and classes. It has been argued on detail. My Lord, there are so many other learned counsel, my Lord, who are also waiting to argue.
Yeah, that's right.
I should restrict it to the absolute. My Lord, I'll also skip para 53 and 54. I'll only, my Lord, take your Lordships to paragraph 55.
It's para 55.
Page 28, paragraph 55. That comes regarding issue 7, whether regarding the eligibility of a person not belonging to a religious denomination or religious group can question the practice of that religious denomination or religious group by filing a PIL. It is submitted that a person who does not belong to a religion or religious denomination cannot question the practice of that religious denomination or religious group by filing a public interest litigation. A brief reference to the articles in Part 3 of the Constitution of India dealing with religious rights would be appropriate. The specific provisions in Part 3 of the Constitution dealing with the freedom of religion are Articles 25 and 26. Article 29 provides that no citizen shall be denied entry into educational institutions maintained by the state or receiving state aid on grounds of religion, race, must be caste, language, or any of them. Article 31 provides that all minorities, whether based on religion or language, shall have the right to administer or establish educational institutions of their choice. Article 16.5 provides that nothing in the article shall affect the operation of any law which provides that an incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. It is submitted that the impact of Articles 29 and 30 may not fall for the consideration of this Honorable Court in the present batch of cases. The aforementioned articles have no impact on Articles 25 and 26 of the Constitution. Article 16.5 is relevant only in the context of the right of a religious denomination to insist that a person belonging to the religion or a denomination thereof alone be permitted to occupy an office in connection with the office of a religion or denominational institution. A person who does not belong to religion A could not have the fundamental rights to claim that he is entitled to practice and profess a religion. He may belong to religion B or C and would therefore claim and assert the right to profess the religion in which he is born or the religion which he professes. But this Honorable Court is to consider a case where a person belonging to religion A seeks to practice religion B. There is no fundamental right available to such a person under Part 3 of the Constitution of India to either question the religious practice of the religion which he does not seek to practice, or a right emanating from any other part of the Constitution of India enabling him to do so. A public interest litigation, as laid down by this Honorable Court in numerous judgments, is taken up to consider the assertion of the right of a person who is disabled from it. At the same time, where a religious practice is in question, then a public interest litigation questioning the same would in effect be questioning the fundamental rights of the practitioners of that religion, where the practice of that religion is in question. This will never be entertained in a public interest litigation. No, my lord, there are other aspects on which, my lord, as I submitted, my lord, either my learned colleagues, my lord, who had argued before me had dealt with that, the solicitor had dealt with that, the additional solicitor general, my lord, Mr. Vaidyanathan, and then my lord, Dr. Dhawan has also dealt with it. It will probably be dealt with this also. But in my respectful submission, according to me, the right under, I'll just sum up, my lord, see, the right under Article, just one, the right under Article 25(1), constitutional right, is to practice the religion which I profess. It is rested on the inalienable principle that I can, when I practice the religion, I should be a believer. If I am a believer, then I am a believer in the core principles of the religion which I profess and practice. I cannot claim a right under 25(1) in derogation or in antagonism to the core beliefs of the religion which I profess and which I seek to practice. I cannot do it in antagonism to that. And the right under 25(1), even for entry, will have to be in sync with the core principles of this. And to that extent, when your lordship say that the right under 25(1) is to be protected, and obviously it has to be protected. It cannot be, it has to be in sync with, when I come to the context in question, it has to be in sync with the characteristics of the deity, which is an integral part of the mode of worship that is protected, adumbrated, and practiced, my lord, by the faith in which I believe. This is essentially what I wanted to say.
Thank you, Mr. Thank you.
I'm deeply grateful to you, sir. Deeply grateful. Yes.
Just a minute. Mr. Gopal, would you like to argue right or you want them to finish the review petitioner? No, if you want, you are most welcome. You can start.
I'll then take over.
Or because they are probably supporting the review petitioner, they can briefly sum up petitioner.
May I set out my position because I'm sitting here? The position is on a point of principle. As a matter of legal construction, I have difficulty with the majority opinion Sabarimala case as a matter of law. And a lot of these questions will have to be first answered in my submission in an abstract manner, without reference below to, shall we say, the facts of any particular case.
Right.
And my lord, they do require some degree of reflection, rumination, which I suppose below in the course of my submissions, we will do it collectively. But it does require, my lord, extreme thought, because we are dealing with very profound areas of personal faith. We are also dealing with collective faith, and my lord, above all, which we should not forget, we are dealing with all religions in this country.
Mr. Gopal, then we would like to hear you in detail, and after let them supplement what has been argued, and then we'll request you to submit it. Mr. Dwivedi, is it up to Mr. Gopal? Oh, yes, Mr.
Yes.
I'll argue after that. I'm for one of the review petitioners. As the president of
We will hear all of you.
After the review petitioners, I'll complete my submission. But both Mr. Gopal Subramaniam and Mr. Reddy will be arguing. After that, on a wider compass of other religions. So I will complete after Mr.
After Mr. Sankaran,
You also, Mr. Singh, we will hear you.
after Mr. Sankaran, Mr. Dwivedi.
We will hear all of you, but only request simply there is no need to repeat. Like Mr. Giri very clearly skipped some of the arguments because rightly so. Earlier it was having elaborately argued. So just briefly please sum up your points.
Since after Mr. Sankaran, I'll submit. I'm on 901.2.
Mr. Gopal.
Yes. Well, I think your lordships will be happy to know I have a one-page note, which I'm handing up. And usually in these constitutional benches, which because I've played a part in that book, I hand up copies to the judges. So if your lordship wouldn't mind, I'm just going to refer to this, nothing else, only these two.
In the soft copy,
Yes.
just indicate where it is there so that we can note
Yeah.
up.
In the soft copy, it's at 1.1, page 863.
863.
Page 863 of 1.1. That's also a two-page answer to the questions, Manoj, broadly. I believe, and I'm completely in accord with Mr. Subramaniam, that we shouldn't be looking at the facts of individual cases.
Once again, one volume.
Volume 1.1, page 863. 863, but your lordship may just ignore that for the time being. I'm just going to only deal with this, Manoj. So, I like I was saying, Manoj, I'm completely in accord with Mr. Subramaniam. We must look at it on a completely broader plane than looking at it from the point of view of Sabarimala. I am appearing for the review petitioner in Sabarimala and some others. We are devotees there, plus other religious groups. I have 2 intervention applications also. But I think when your lordships are looking at it from the perspective of 9 judges, we are transporting ourselves back to 1950 effectively. And all the judgments that have come before would possibly give some guidance, would give a template about what we are actually grappling with. So if your lordships don't mind, the approach that I am adopting is as follows. The first is to look at the larger scheme of part 3 of the Constitution in the backdrop of the religions and the denominations that populate this vast nation, this civilization, as Dr. Taban said. That's relevant. The second is bearing in mind what specifically are the religious practices and issues that we constantly see. We have been seeing a lot about temple entry because that is an issue in one case in this batch. There are other cases also in this batch looking at different aspects. One is looking at mutilation, the other is looking at Parsi woman marrying outside her community if she's allowed entry into the fire temple of the Agyari. there are different issues that keep coming at every stage. We've had the issue with the hijab in schools. So there are multiple issues which will arise in a country which is so rich in its culture and so rich in the practices that you have. All of this will be encompassed in it. So it's in that backdrop, and in the backdrop particularly of part 3, I was wondering if we could explore how 25 and 26 and its interaction lies and what flows from it. This is 2 pages, my lords, which I've handed up back to back. So if your lordship will kindly take that. On the front is articles 25 and 26. I've set that out and I've highlighted the color coded, so your lordships can see what I feel requires emphasis. But just before that, just for a minute, if your lordship will take the constitution, there's a certain scheme I wanted your lordships to go through as far as part 3 is concerned. If your lordships will indulge me in coming to part 3 and looking at some specific provisions for this. I think also to partly answer some of the questions that fell from the court. Article 13, my lords, we can start with. Ladyship Justice Nagaratna on the first day had asked what is the scope of this existing law.
Existing law is defined.
Correct. It's defined.
Article 366
Correct. In 366(10). So is also continuance of laws in force under Article 372. As also the expression laws in force, which is used in Article 13, Clause 3. Right, Manoj? Now, there is at least one judgment in the 1950s which specifically says laws in force and existing law effectively means the same thing. It will be there in my written note. There is a judgment of your lordship which says so. I don't believe too much flows from it, except perhaps in a narrow area where custom and usage the question may arise. If you see Article 13, subclause 3, in this article, unless the context otherwise requires, law, and I'm looking at law, includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage. 13, 1-3. It should be at page 11. 13, subclause 3, the definition of law, which includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage, having in the territory of India the force of law. And B, laws in force includes laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. Now, as your ladyship rightly said, 366 subclause 10 defines existing law, and 372 also your lordships may see at whatever time.
10.
Yes.
Custom and usage is not included.
It's not expressly.
Always by an authority made law.
That is correct. That is correct. That is correct. So there is a mismatch in the language of laws and force here, as well as 366(10). But for a minute, if your lordships will see 372, Article 372, which is page 414.
Yes.
Which deals with continuance and force of existing laws and their adaptation, notwithstanding the repeal by this constitution of the enactments referred to in Article 395, but subject to the other provisions of this constitution, all the laws in force in the territory of India. Your lordships note the laws in force phrase is used. But again, once again, and this is where I think some problems may arise, laws in force definition in Article 13(3) is only for the purposes of that article. Only for the purposes of 13. It doesn't appear that it would apply to where the expression used outside of part 3. But this uses the words laws in force in the territory of India immediately before the commencement of the constitution shall continue in force therein until altered or repealed, etc., etc. And for the purpose of bringing the provisions of any law in force in the territory of India into accord with the provisions of this constitution, the president may by order make such adaptations and modifications, etc., etc. And explanation 1, if your lordship will come to, just after 3, the expression law in force in this article shall include a law passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that it or parts of it may not then be in operation either at all or in particular areas. Now, just coming back to part 3 for a minute. After 13, if you see where the rights actually start in 14, these words are important for two aspects of what we have been debating for the last several days. One is with reference to constitutional morality, with reference to morality and the expression it uses. And second, about the operation of fundamental rights. 25 is admittedly an individual right. 26 is admittedly a group right, a denominational right. The question is, who are these rights against? Which is why the questions again came on the first day with reference to vertical and horizontal. Just see Article 14. 14 says, the state shall not deny to any person equality before the law, etc., etc. So the state shall not deny. So it's couched in negative terms, and the obligation is cast not on individual temples or denominations or groups, but on the state. So this is clearly a vertical right. 15.1, 15.2, interesting to note how it's phrased. 15.1 says, the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Please note, sex is used here, but you will find later when we come to 29.30, it's not used there. So, based on gender, you can have classification there. You can't have it here. And who can't have it? The state can't have it. But other individuals can. If there's a private company, for example, and my company, I recruit only women in employment, I'm entitled to it under the Constitution. Nobody can raise a question. Now, if that question cannot be raised against a private company, where does a religion or a denomination stand in this scheme of state, then corporation, educational institution, religious denomination?
Now, rules were challenged.
Correct.
So 3B is it is a subordinate legislation.
That is correct. That is correct.
Kerala Act.
Yes, but that is the Temple Entry Act. Now, in the Temple Entry Act, rather than allowing the entry of those women in that age group, the Act bars it. Correct. So, it was an indirect challenge to that. Yes, absolutely.
Custom and usage.
Based on custom and usage. The question is whether a right by an individual, which was what was, I think, being discussed just with Justice Giri just now. Mr. Giri just now. The right that is being agitated, who can it be agitated by? And more importantly, against whom can it be agitated? If you see 15.2 for a minute now, which is in contrast with both 14 and 15.1. No citizen shall, state doesn't come into the picture. No citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. So 2B is with reference to funds which are of the state and used for the public. But A is not. So, if the access to restaurants, if the access to hotels, places of public entertainment and shops, there is discrimination on any of those grounds, that discrimination, if it's not being done by something which is run by the state, it's being done by private individuals, corporations, the citizen is given that right under 15.2, so it becomes a horizontal right. Which is why the distinction between the vertical and horizontal right comes into play when we look at the opening words of 25.1a. Because 25.1a says not only public order, health and morality, but also other provisions of this part. It's not all provisions of this part that 25 has to worry about. It's the places where horizontal rights are being agitated. Which is why identifying what those provisions are becomes critical, which is why I'm undertaking this exercise. If I see 15.3, yes, I'm grateful to Shutanjay. He says 15.2 doesn't say places of religious worship. It doesn't say that.
That has been argued by Mr. Vaidyanathan.
Yes, so I'm not going into that.
Vaidyanathan indicated the distinction.
Yes. So I'm not going into. I'm just mentioning that.
The enabling power of 25 to be
Yes.
of entry.
Correct. But I don't want to revisit it. Solicitor says it was introduced and deleted. 15.3 says nothing in this article shall prevent the state from making any special provision for women and children. And this not preventing the state, which you find in 25.2, is an expression which is used some 60 times across the Constitution. showing that really, rather than empowering, all it says is, look, this is not an obstacle for you. It's a message to the state that when you make this law, this will not come in the way. Therefore, in 15.4, in 15.5, in 15.6, the same expression is used again and again. Now, if you come for a minute, my lords, to 15.6 or 15.5 end and 15.6, because I have an argument on this as well. When it's talking about reservations, at the fag end of 15.5, your lordships will find that it's whether aided or unaided, this is at the end of 15.5, whether aided or unaided by the state other than minority educational institutions referred to in clause 1 of Article 30. So, when reservations are being provided, minority institutions under 30 are excluded by the Constitution. I'll explain why I'm mentioning this, but I'm drawing your lordship's attention to this. It's similar in 16.6 as well, 15.6 as well. 16 is also couched in the same manner. There are no horizontal rights there. It's again nothing in this article, nothing in this article, and with reference to public employment, which your lordships are aware. Now, 17 is a central aspect of the argument. Abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. It's very strong terms to be used in a constitution. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. Now, this is clearly a horizontal right. And if for a minute your lordships will indulge me, after 17, I'm just leaping to 23 and 24 to illustrate what the other horizontal rights are.
Mr. Gopal, 19.
I'll come back to 19. I just wanted to read these three together. 17, 23, 24. I'll come back to 19. Just for a minute.
You must also keep in mind
Yes.
the expression untouchability is within inverted commas.
Absolutely.
So what the Constitution framework has
Yes.
in mind
Yes.
when it is untouchability is
Yes.
bearing in mind the historical
Absolutely. No question.
and the
No question.
social, you see,
Absolutely.
practice, so to say.
Absolutely. Absolutely.
This is what they had in mind. They made it a.
There's no question about it. There's no question. In fact, this
Therefore, it
is
is not any kind of, you see, prevention or whatever.
It's not. It's not. It's very clearly understood at that time, and that's why Article 17 has to be read not in an isolated fashion. It has to be read along with the 25(2)(b, making it clear for entry. It has to be read with the provisions in 331 onwards, which specifically provides for a commission. It provided for the only reservations that we had in the country in 1950 as a right, as an assurance, was the rights which were available to the SC, STs and the Anglo-Indians in the legislatures and parliament. That was only constitutional assurance. Reservations for education and reservations for employment was not a constitutional assurance. It was enabled by 15 and 16 if the state decides to make that law. But the constitutional assurance was because we had that in mind. The reason I mentioned this, and I'm grateful to ladyship for that observation about the inverted commas, is because one of the arguments that we have had in the earlier Sabrimala round was to say that this untouchability could possibly include anybody who is excluded from any particular practice. That is absolutely not. It is only and only for those who are known as the scheduled caste today. The schedules, in fact, we had occasion to assist your lordships on this earlier, comes from the 1935 Government of India Act, not any schedules to this constitution, where actually each of the castes, which subsequently came in the presidential order, were listed. That's why it's referred to as scheduled castes and scheduled tribes. No, I'm sorry. So the scheduled castes and their right here, that this so-called taint which existed all this while is completely abolished, and more importantly, any disability arising from it goes, means that it is something which has to be honored by every individual, every entity, no matter who or what it is. There is no question of any classification, exclusion on this ground. There is absolutely no ground about that.
Horizontal right.
It is absolutely a horizontal right. The reason why I want to read 17, 23 and 24 together before coming to 19 is because these, in addition to 15.2, are the horizontal rights we have. Just for a minute, 23, if I may. traffic in human beings and begar and other similar forms of forced labor are prohibited. Again, strong phraseology. I'm sorry, this should be page 39, Article 23. And any contravention in this provision shall be an offence punishable in accordance with law. So 17 and 23 are creating offences in the Constitution, not waiting for a penal code to come along. 2. Nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service, the state shall not make any discrimination on grounds only of religion, race, caste, or class, or any of them. Conscription, etc., would come under this. 24. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. So these are absolute bars. Now, to link these four, or in fact the latter three, if I can take your lordship just for a minute to Article 35, all part of part 3. And Article 35 starts with notwithstanding anything in this constitution. They wanted Parliament to make that law because the offence is recognized but the punishment is not prescribed. The procedure is not prescribed. None of that is there. And Parliament shall, as soon as may be, after the commencement of this constitution, make laws for prescribing punishment for the acts referred to in subclause 2, small subclause 2. The reason why I mentioned this, Manoj, is the Protection of Human Rights Act. It had an earlier name, the Untouchability Offences Act 1955. As soon as maybe it was 1955 when that act came in. That act is at the moment in volume 4.1, page 450. It's worth reading specifically on this point because it deals with religious and religious denomination. So just for a minute, if your lordships don't mind, I'll just refer to it. So it's at, I'll just mention volume 4.1, page 450. Now, at that specific definition, section 2D, it deals with places of public entertainment, etc. But 2D specifically defines place of public worship. Allow me to read it. Place of public worship means, it's volume 4.1, page 450. At 451. Volume, it's on the screen, my lords, if your lordship see.
Put the tag.
If you're on the screen.
Yeah, it's on the screen. So 2D at page 451. 4.1.
Place of public worship.
Place of public worship, that's it. Means a place, by whatever name known, which is used as a place of public religious worship, or which is dedicated generally to, or is used generally by, persons professing any religion or belonging to any religious denomination or any section thereof, thereby the phrases in 26 are there, for the performance of any religious service or for offering prayers therein, and includes, please note this, all lands and subsidiary shrines appurtenant or attached to any such place, a privately owned place of worship which is in fact allowed by the owner thereof to be used as a place of public worship. And 3, such land or subsidiary shrine appurtenant to such privately owned place of worship as is allowed by the owner thereof to be used as a place of public religious worship. And then, section 3, next page, 452. Punishment for enforcing religious disabilities. Sections 3 and 4 are critical. Whoever on the ground of untouchability, once again inverted commas, prevents any person from entering any place of public worship which is open to other persons professing the same religion, please note same religion, or any section thereof as such person, or from worshipping or offering prayers or performing any religious service in any place of public worship or bathing in or using the waters of any sacred tank, well, spring or water course, river or lake or bathing at any part of such tank, this could include the Ganges, etc., water course, river or lake, in the same manner and to the same extent as is permissible to other persons professing the same religion or any section thereof as such person, shall be punishable with the term, etc., etc. Punishment is there, and then the explanation. For the purpose of this section and section 4, persons professing Buddhist, Sikh, Jaina religion, or persons professing the Hindu religion in any of its forms or developments. They've used the word development when they could have used denominations, including Veerashaivas, Lingayats, Adivasis, followers of Brahmo, Prarthana, Arya Samaj, and the Swaminarayan Sampradaya, shall be deemed to be Hindus. the section 4 is dealing with social disabilities and makes it clear in the explanation at the very bottom of page 453 that for the purpose of this section, enforcement of any disability includes any discrimination on the ground of untouchability. Justice Antonin Scalia, who the learned Solicitor General had referred to, had come for a conference in the mid-1990s to Delhi, in fact. And one of his lectures, when asked, what is it that you believe America has done legislatively better than India? He said it's the Civil Rights Act. He believed, perhaps that is true, that the problem is that assuring to every individual the rights that when you have a constitution which has fraternity at the front of it, the fact that you don't have a comprehensive Civil Rights Act which takes care of all these issues vis-a-vis all communities and all castes is perhaps a failing of the state. Now I'll come back. Now the reason why I showed this is to show that 17, 23, 24 along with 15.2 are horizontal rights. There aren't, from my reading at least, any other horizontal rights that I could find in the constitution. This becomes relevant for the interpretation of 25. But for a minute, as Lord Justice Bagchi mentioned, may I take you to Article 19. So 19, my lords, provides for A, freedom of speech and expression, and I'm drawing your lordship's attention to C, which is to form associations or unions or cooperative societies. The reason I'm looking at A and C is for two reasons. One, A and C are controlled by 19.2 and 19.4. 19.2 and 19.4 are the two clauses, the two controlling clauses, which use the word morality. There is an application of mind by the framers, by the founding mothers, specifically to employ different controlling phrases for each of the clauses in 2, 3, 4, 5 and 6. This becomes relevant when we look at the controlling phrases used in 25 and a part of it in 26. It is deliberate because when you look at 19, we understand what they were thinking, what direction they were taking. They were thinking the forms of expression that the person who wants to live freely would have. He would first want to speak and express himself. So that is protected by 1A. 2 is to assemble peaceably. So you meet. C provides for associations or unions, or now cooperative society. So you organize yourself. The way I see it as far as religion is concerned, Article 25(1) gives me the right to believe. Or profess also. Profess, practice properly. But for profess,
How did Mr. Gopal
yes,
read
yes,
19(1)(a)
yes,
expression
yes,
with the word profess
yes.
any religion in 25(1)?
So the way I would read it is this: the 19(1) is right.
19(1)(a) expression
Yes,
to be a general law,
yes,
whereas 25(1)
yes,
pertaining to professing religion,
yes,
a special law, and thereby any professing of religion should be governed by 25(1) and not under the generic ambit of 19(1)(a).
that is absolutely
Because
yes,
after all, every professing of religion is an outward expression of an
absolutely, it is.
So
It
we proceed.
yes,
Why I ask this question is because of Mr. Giri's
yes,
contention of individual
yes,
being completely emasculated, even to question the religious practice which is propped up
yes,
by his denomination.
yes.
I say that I am a granular part
Yes,
of the denomination.
yes,
And the denomination professes as a religious practice, which I feel
yes,
runs counter to the tenet of the very faith.
yes,
Now, the arguments advanced till now is I can't because I'm a believer.
yes,
That may be good on a generic moral or emotional way.
yes,
But when you come to assertion of a legal or constitutional rights.
Yes.
Will 25(1) get colored from 19(1)(a)
Yes.
and thereby must be read harmoniously with 26(b) and not
Absolutely.
subordinate.
Absolutely. So let me just explain as a response. When birth takes place and expression starts, the expression is in multiple forms, only one of which is dealing with faith or dealing with religion. If I want to believe, I could easily want to be an agnostic or an atheist, in which case I don't want to believe. But still, my right.
Agnostic or an atheist does believe. It does not believe in
So-
the idea that there is a maker
Correct.
has
So,
created.
actually, the atheist would be a strong opposer of it, and agnostic would say, look, it doesn't trouble me in the least, but I'm not signing up for this. But either way, all these three will. Sorry.
Atheist doesn't believe in the existence of God.
Yes.
Agnostic believes in a higher strength, or what to say, a higher, some kind of a form or something.
I'm not sure about that last bit.
Agnostic doesn't believe
Yes.
in God, but
Yes.
he believes in a higher power.
Yes.
Ultimately,
Yes.
whatever it is, all are believers. Either they believe no God or they believe higher God.
Perhaps. Perhaps. But what I'm saying.
Believe in idols or something.
Correct.
All are believers.
What I'm saying is for that.
Yes.
For that spiritual aspect, let me put it like that. For the spiritual aspect of the expression of the spirit, I'm sorry. Yes, so for the spiritual aspect of a believer, not a nihilist, I would say that the right would come from 25(1). But that is the spiritual side of me. But if I want to express myself in different fashions, whether I want to express myself in a public pulpit, or if I want to be in a debate, or if I want to write in a newspaper, all of that comes from 19(1)(a). But to answer your lordship's question, if I am a person who has initially embraced a particular faith, and then I find that there's some practice which is abhorrent, and I want a correction of that faith, if I want to express myself to correct that faith, that is not an expression of 25(1), because 25(1) is a take it or leave it provision. 25(1) says for me to propagate or practice that religion as it stands, you have that right under 25. But if there is a dissent, if there is a course correction that I want to agitate, I use my 19(1)(a) right, but I'm not using it against the state. I hope I'm making myself clear. It's not a right available to me against my religion.
19(1)(a),
Yes.
as you say,
Yes.
is a horizontal right.
Yes.
And therefore,
No, 19(1)(a) in my view would not be a horizontal right.
it's not a horizontal.
I'm not saying that. I don't think it's a horizontal right. Because if allow me to read it. It says all citizens should.
Social Kishore has said it's a horizontal.
Yes, but
We have to look into social.
now the problem with that is if I say it's a horizontal right, it can be directly enforced by somebody who claims that look,
It's
there's a violation.
hate speech against an individual.
And if there's no law.
Put to the court
Yes.
and enforce his fundamental right.
In my view, 19(2) gives the answer to that. 19(2) gives certain controls, and those controls alone: incitement, libel and defamation and slander, integrity and sovereignty of the country. Those are the grounds.
They are,
If there is some, yes,
are not the very nature of defamation.
yes,
It shows that 19(1)(a)
Yes.
is not directed against the state
yes,
or not enforceable against the state or by the state.
the problem
Is
is
definitely
Yes.
enforceable
yes.
against anyone who suffers defamation,
So let me give an example, Manoj.
who suffers injury.
I-
Because
I want to give you an
expression by
I want to give your lordships an example. I'm a school student. I stand up and keep interrupting the class saying I have a 19(1)(a) right. It's my horizontal right. I'm expressing it. Is this wrong for the teacher to say I'm throwing you out of class because you're disrupting it? Can the student come back and say 19(1)(a) right has been violated? My answer is no. I'm clear about this. There is no horizontal right available for that person under the Constitution. There may be different disciplinary regimes, but those disciplinary regimes cannot be challenged by saying that my 19(1)(a) right has been violated. Because there are spaces within which discipline is required, speech of this sort cannot in fact be utilized. Offices wouldn't be able to function. Most places where you require some level of restraint wouldn't be able to function. In fact, I mean, I know this as a personal tale. The Official Secrets Act provides that civil servants, if they speak out openly, honestly, and truthfully about what is happening in their offices, they are not protected by 1901. Because the Official Secrets Act says that any action of this sort can.
Because of the reasonable restriction of security.
It can't be a reasonable restriction. Unless it is on sovereignty, integrity of those grounds. If I'm talking about a minister having taken a bribe.
Legislative competence.
Yes.
Whether the restriction is reasonable or not is the principles of proportionality. Like the student asking a question.
Yes.
To the extent the student disrupts.
Yes.
To the right of expression of the teacher.
Yes.
It is a question of proportionality, not enforceable.
But
there is a difference between proportionality and enforceable.
Well, the
teacher cannot stop all students. But again, the student cannot stop the teacher. So whenever such a situation comes before us, we apply the test of proportionality. But Mr. Gopal is examining whether enforceability comes into question. Enforceability, definitely it's a horizontal right.
But if I may, in Ramesh Thapar, which is one of the early cases of this court, when the very same question arose, what was the circulation? No, there's a reason. There is a reason why I'm saying that. In Ramesh Thapar, the reason why. Allow me to complete. In Ramesh Thapar, the reason why the law was struck down was simply because public order was not there as a ground in 1992. So they had to come up with the First Amendment to the Constitution, bringing it in as a ground and bringing in the word reasonable as well. Now, if that is the strictness that we attach to the adjudication of this provision, I ask myself, if there is an officer in government who says, look, this minister has been taking a bribe, he's corrupt, etc., it's not defamatory or scandalous. It doesn't fall under any of these grounds.
We understand. You are saying, not child under 91A,
Mr. Gopal, your time will be over by 1 o'clock.
No, I'm not giving a timeline to me for the first time. It's not been enforced so far.
5 you have given it 55 minutes.
To be fair, I'm not trying to repeat anything. I'm just trying to take your launches through.
You are not saying that you are.
Sorry. I don't mean to take any more time than is absolutely necessary. Now, it's in this context now, if I can take your lordships, the one page which I handed up. And I want to give your lordships what I believe is the appropriate interpretation. And this is not on behalf of the Sabrimala devotees, etc. I believe 9 judges have convened to interpret this after 75 years. We have to ensure that it goes on for a while, and we give you the assistance no matter what the client wishes. Now, Article 25. We have marked subject to public order, morality and health. Morality, as your lordships have seen, comes in 1902 and 1904. The only point that I was coming to was you first express yourself, then you decide to assemble, then you form an association. So if you want to formalize a religion, you will first express under 25(1)(a). You will then form, if you have to form a trust or a society or whatever it is, for the purposes of implementing your rights with reference to the religion, of setting up a temple, of setting up a charity, of setting up a school, you will do that under 19(1)(c). You will first exercise your right under 19(1)(c) for that purpose. And then we go back to 26, 25, whichever will apply. Now, public order, morality and health, and to the other provisions of this part is the phrase used here. The phrase used in 26 is subject to public order, morality and health. Now, I must tell your lordships, I have learnt a lot more about this case in the last 5 days, hearing all my friends arguing it, and I have had to vex myself repeatedly on what could be the best way to interpret and harmonize these two provisions. My view is as follows, and I'll just explain. When the words other provisions of this part is used in 25, the other provisions which are being referred to are the horizontal provisions of part 3. Therefore, the other provisions to which it will be subject would be 15(2), 17, 23 and 24. I hope I'm making myself clear. That is what I believe is the interpretation of other provisions of this part. The question secondly is with reference to morality. Now, I disagree with the solicitor's formulation because your lordships must know there are three sets of arguments before your lordships. One is on behalf of the government, and there was some board, I must tell your lordships, in all honesty, Dr. Singhvi has been representing them. They have been going from one end to the other. They've taken different views at various stages of this litigation from the beginning. Now, governments, boards, etc., boards are creatures of the government, they want to control. So their interpretation is going to be very wide with reference to 25(2)(b) and its application to 26. They are going to say it applies. They are going to say yes, we can make laws on virtually everything. But suddenly, when it comes to judicial review, there's a screeching halt. No, but you please keep your review within a narrow passage. We won't go the whole hog. So that is one set of arguments that your lordships have heard, throwing constitutional morality overboard and saying let's go with public or social morality, which we will determine. We are the elected representatives of the people. That's section 1. Segment 2 are the arguments that Mr. Vaidyanathan, Mr. Giri, Mr. Deepak, etc. are taking, which is on behalf of temple management, tantris, etc., devotees, etc. Where we are saying, look, 26 is not meant to be controlled by 25(2)(d). It is not meant to be controlled. It doesn't anyway do violence to the entry provision with reference to the Article 17 covered people or anybody else. It will not, and I'll explain why. That's the second set of arguments, saying that therefore we believe that the scope for making law to restrict our rights is extremely limited and narrow. The scope of judicial review, in our view, is open wherever that issue arises and a law is made and there is a fault found with that law. Obviously, all the grounds which are available to challenge the law is available, so we can't run away from that. The only point we take is, can you come first as a non-member of a community, second in a public interest litigation, and third agitating a fundamental right, to say course corrections are required? Is that possible? We believe no. And we believe...
Subject to other provisions of this part,
yes,
would include Article 26.
Yes, 100%.
Subject to other provisions of this part,
100%.
don't look at only 14, 15.
Correct. Exactly.
Article 26 is also there.
Absolutely. Which is why between 25 and 26, there's no question that 26 stands above. And Justice Bagchi had mentioned, I think 2 days ago, that what is the significance of the absence of the words subject to in Article 26?
No, I'm not on that.
No,
what I meant was,
yes,
subject to other provisions of this part
correct,
means 25(1) is, or you can argue that 25(1) is also subject to 26.
I agree. That is why I'm saying. I'm completely in agreement. I'm saying the corollary to this, to support what Ladyship is saying, is the fact that in 26, similar words are not there. Otherwise, a confusion could have arisen where in 26, if they said that 25(2), which provides for the state to make the laws on all these grounds, would equally apply, they could have said subject to 25(2), 26 will have these limitations. They didn't say that. They didn't say notwithstanding. They didn't use any of the tools which is available to them, which are readily employed throughout the Constitution. It's not used. Now, the third segment of argument, what my friends are taking, I'm presuming what they are saying, is that the scope of state control is substantial and the scope of judicial review is substantial. So everything can be controlled. 26 will be controlled by 25(2), and therefore all rights of the fundamental rights chapter will apply, not only the horizontal rights as I am arguing. I hope I'm making myself clear. These are three segments of argument. So if your lordships feel we have heard the petitioners for a while and we find discord and disagreement, it's because we're not all really petitioners. Mr. Mehta is clearly appearing for the Union of India with a completely different cake to make. We are not them. They are attempting to control us. We are objecting to it. I hope I'm making that position clear. I think we're all ad item on that position. Now,